Hey Calgary, CJSW 90.9 FM is independent, volunteer run, and listener funded.
Hello and welcome back to part 2 of the PBSC Hearsay podcast with Professor Jennifer Koshan and myself, Madeline Anthony. To recap part 1, we were discussing the 3 bills that have been passed in Alberta, Bills 26, 27, and 29, which deal with the rights of gender diverse youth in the areas of education, healthcare, and sports. We will be continuing that discussion today with part 2. Thank you for tuning back in.
And so what all of that means, and this is the case that's currently before the Saskatchewan Court of Appeal, is that courts may continue to have a role even after Section 33 is invoked, because while they can't strike down a law where Section 33 has been used to shield that law from a charter challenge, they could still grant a declaration that the law does violate the charter rights of trans and gender diverse youth, and then that gives the public information that they can use when they go to the ballot box next time around. So I haven't yet mentioned the litigation in Alberta, and I should probably do that. As soon as these laws were passed in December of last year, Egal and Skipping Stone Foundation filed a charter challenge focusing on Bill 26, which is really important. That, again, is the healthcare bill. And the litigation that's happened in the other provinces so far has been focused on the education context. So I think it's really important that this is going to be the first litigation in Canada challenging these healthcare restrictions that are being faced by trans and gender diverse youth. And they were in court last week, actually, arguing for an injunction, which, again, is an order on the part of a court that kind of prevents the law from coming into effect. It's an interim injunction, which means that, eventually these issues will be litigated. The court will hear full arguments on these issues. But the harm to the group in question is thought to be damaging enough and serious enough that some sort of preventive remedy is necessary. And so the judge didn't make a ruling in the case. They reserved judgment, but hopefully we will have a decision soon on the constitutionality. Well, not on the full constitutionality of Bill 26, but at least the question of whether it presents irreparable harm for trans and gender diverse youth such that an injunction should be granted.
Yeah, there's so many moving pieces when it's so many different provinces and so many different aspects of the law. And it's funny, Section 33, and that probably speaks to my lack of focus in this area before I came to law school. I didn't know that it existed until Constitution. And I was in Constitution being like, oh, wow, that's it. Like kind of one of those things that sort of shakes your faith a little bit in the protections that the charter is sort of supposed to give, that you can throw this clause in and all of a sudden those protections are gone. And I feel like you said, like in a case like this, when it's such a vulnerable group, 5 years is a significant amount of time that becomes sort of at risk more so than already present just by the nature of our society. And so it is watching all of this sort of play out, starting in kind of now that we're 2023 for New Brunswick's law. We're already 2 years into having some of these policies and laws in place. When that irreparable harm sort of factor comes in, it just all takes on a bit more of a weighty nature to it. And I feel like usually when we learn about the Constitution and where it applies, lots of times it's in sort of these bigger picture, longer term issues. I feel like this one is so immediate that it'll be interesting to see how quickly some of these cases move through the courts. And this is sort of a personal interest, but is the Saskatchewan Court of Appeal case, will it likely go to the Supreme Court? Does it feel like that's kind of where this is all heading?
Well, that's another really interesting angle on this issue. So The Saskatchewan case was argued back in September of 2024. I should say for the record that I participated in that litigation because I do some work with LEAF, the Women's Legal Education and Action Fund, and they were an intervener in the litigation in Saskatchewan. So I participated in the drafting of LEAF's factum. I think many people are expecting that regardless of what the outcome in the Saskatchewan Court of Appeal case is, the issue is important enough that leave to appeal to the Supreme Court will likely be sought. We should pause to note here that you don't automatically get a right of appeal to the Supreme Court of Canada, except in very limited circumstances in criminal cases. And so it is up to the court to decide whether to hear the case. But they're hearing a very similar case right now about the role of Section 33 of the Charter in a case out of Quebec involving Quebec's religious symbols and religious clothing law. So they did grant leave to appeal in this case recently, which involves Quebec's use of Section 33 to protect this so-called secularism law that prevents public servants from wearing religious clothing. And that law has been challenged by a Muslim woman. There's an argument being made that it adversely impacts Muslim women on the basis of their religion and their sex as they intersect. But the government did use Section 33 to protect that law. And so part of the issue that's going before the Supreme Court, again, is this question of what is the role of courts when a government has invoked Section 33? Is it still open to a court to rule on the constitutionality of the law, even if they're not able to strike that law down? And so depending on what happens in that litigation, that may affect whether or not the case involving trans and gender diverse youth also goes to the Supreme Court of Canada.
Mm-hmm. And then the Alberta case is currently there. They've reserved, so we're waiting for an injunction. Is the grounds under which that one's being challenged, is it Section 7 and Section 15 as well?
Yeah, so Section 7, again, protecting the right to life, liberty, and security of the person. Section 15, equality rights, so arguing that the bill is discriminatory in the case of trans youth. I particularly think that's a strong argument because it should be said that this Bill 26, focusing on hormone therapy, does specifically target gender-affirming hormone therapy. And we can think about other youth who are prescribed hormone therapy for reasons related to something other than their gender identity. There's no prohibition against hormone therapy in those situations. So we definitely have a situation here where trans and gender diverse youth are being targeted. And the Supreme Court hasn't yet recognized gender identity and or gender expression as a protected ground under Section 15 of the Charter, but I think most people expect that that is only a matter of time. The court has ruled on other cases involving trans folks and has said that has recognized that it's one of the most vulnerable groups in society whose very existence is sometimes being challenged by governments. And so I don't think that is a particularly contentious issue. But the Section 15 arguments, I think, are particularly strong. Security of the person under the Charter protects freedom from state interference with one's bodily integrity and freedom from serious state-imposed psychological stress. I was just teaching the Morgentaler case yesterday in constitutional law, and that's where those definitions come from. And I think security of the person is very strongly engaged in the case of medical treatment that may actually be in the child's best interests according to the opinion of their own doctor, may be supported by the child's family as well as their own interests and desires, yet is still being restricted by the government. And then the third right that's being used in the Bill 26 case is cruel and unusual treatment and punishment under Section 12 of the Charter, which is also at issue in the Saskatchewan case. And that's an interesting one because Section 12 hasn't been applied that much outside of the criminal context. Usually it's used in cases involving things like mandatory minimum sentences. And so there's really an opportunity for the courts to think through what Section 12 might guarantee outside the criminal law context. So those are the three rights that are being invoked in this case.
I did not realize Section 12 was being invoked, so that's interesting.
Mm-hmm.
And for listeners like less familiar with how challenging legislation works, if Section 33 is invoked, or if the charter arguments were not to succeed, are there other grounds under which this could be challenged? Would it then become sort of an individual case-by-case basis that you'd kind of have to plead your medical need to the court, or would it kind of just be an end-of-the-road sort of situation?
Well, one argument that is potentially very interesting that we haven't talked about yet is that we still have something in Alberta called the Bill of Rights. And the Bill of Rights is just a statute. It's not actually a part of the Constitution. But it was amended back in the fall by the Alberta government to protect the right not to be subjected to or coerced into receiving medical care, medical treatment, or a medical procedure without consent. Now, that's the right not to be coerced into receiving certain kinds of medical care, but we might think that it also extends to a prohibition not to have access to the medical care that is in one's best interests, and so potentially a challenge could be brought under the Alberta Bill of Rights. I think also this section under the Alberta Bill of Rights adds on to this argument that the legislation affecting trans and gender diverse youth is quite arbitrary. It's kind of all over the place. Parental rights on one hand, not on the other hand. Medical care and decisions about medical care are important enough to include in the Bill of Rights, except not for trans youth. So we see a lot of inconsistency here on the part of the government, and I think the arbitrariness of these laws will certainly be a strong argument. But if the government does invoke Section 33 in response to a court ruling that goes against these laws, then potentially the Bill of Rights is an avenue, but they could also say that the law applies notwithstanding the Bill of Rights and notwithstanding our human rights legislation in the province. So that doesn't leave trans and gender diverse youth with a lot of legal options. But we also have to think about the role of physicians and medical practitioners in this context. I've heard some of them speak out very passionately about their own duties to protect trans and gender diverse youth and to offer them the care that is consistent with the Hippocratic Oath that doctors take. And so they're being put in a very difficult position if they're being told by way of law that they are not allowed to assist families in making medical decisions that may be in the best interests of trans and gender diverse youth. So it may be that doctors can continue to provide avenues of treatment, although they're also putting themselves in a very challenging position if they are going to be breaking the law potentially in these cases. In some ways, this reminds me of the debates that we had around medical assistance in dying, when it was still a criminal offense to assist someone to commit suicide. And the story was that many doctors and medical professionals were continuing to provide these sorts of services to their patients. They didn't necessarily come under the scrutiny of the law. So law isn't always a complete barrier to these kinds of things continuing to go on in practice.
And in this sort of scenario of having these individual provinces sort of pass these laws, and obviously Alberta being the healthcare specific one, what will that create sort of a patchwork of how care can be given? Because I feel like the common understanding is that it's free healthcare across Canada, that our healthcare system is very national, and that it's obviously something that we're sort of proud of as Canadians putting forward. And all of a sudden you now have a box just kind of middle of the country that doesn't necessarily have a healthcare for all structure with these bills. Would that lead sort of for those seeking treatment? Would they be able to leave the province and obviously asking someone to leave their home to seek medical care is a big ask. But if worst case scenario, sort of the avenues for healthcare kind of are shut down, how does it work when there's one province that's changing how their healthcare is administered?
Mm-hmm. So we could perhaps draw an analogy to abortion here and access to abortion services, because even though the criminal law on abortion was struck down in the Morgentaler case back in 1988, there's still some provinces that don't have a lot of access to abortion services, and some of the maritime provinces in particular are ones where access has been a real issue, as well as other sort of rural and remote parts of particular provinces and the territories. And there was a time when the government of Prince Edward Island would not provide abortion services intra-provincially and required people seeking abortions to go outside the province to receive those services. That law ended up being challenged under the Constitution as well, and before it went to court, the government and the charter claimants kind of came to a settlement, and the government revoked this particular policy. But I think it does provide a very important analogy in the sense that we're also talking about a situation where delay can really result in harm to the person in question. And so it may be possible for trans and gender diverse youth to seek things like hormone therapy in other provinces. It's somewhat different than an abortion in the sense that it's an ongoing therapy rather than a one-time medical treatment. But your question makes me also think about the fact that we have something called the Canada Health Act in Canada, which protects our access to health care. And sometimes in the past, the federal government has held out the possibility of sanctions against provinces that aren't fulfilling their obligations under the Canada Health Act. And certainly that was the case when Prince Edward Island and New Brunswick were not providing appropriate access to abortion services. There was a threat to withhold their funding under the Canada Health Act. And so that could potentially be an option for the federal government as well. But, you know, it's that kind of takes the issue to a different level where it then becomes kind of a battle between the powers that the provinces and the federal government have over healthcare, because it's an area of shared responsibility between the provinces and the feds. We also have to think about the fact that there's a federal election coming up very soon. A Liberal government might be willing to take a stance against the sort of thing that the UCP government is doing in Alberta with Bill 26. But if a Conservative government were elected, there's already fears that that government may not be supportive of the claims of trans and gender diverse youth. So there's a lot of importance riding in that federal election as well.
Has the federal government made any statements up until this point of how they feel about what's going on in Alberta and these bills?
I know some concerns were expressed at the time that these bills were being debated, but nothing formal has been done as far as I know.
And so with sort of all of those moving pieces and the ongoing kind of legal actions, where do we kind of stand now, and where is it all going, to the best of your knowledge?
Yeah, so I guess in the most immediate future, we're waiting for the decision of the Alberta court on whether an injunction will be granted in relation to Bill 26. I think that's going to be a very important decision. Hopefully there'll be a written decision, and if there is, I will write a blog post on it. So listeners may be interested that we have a blog at the University of Calgary Faculty of Law where we write commentary on legal developments in the province and more broadly. And so I've been blogging on the decisions out of Saskatchewan so far, and I'll certainly add a blog post on the Alberta decision if that's the case. And I try to break it down in a way that hopefully it's understandable to people who don't have legal training. And then, of course, we're waiting for the Saskatchewan Court of Appeal decision as well, which is a really important one in terms of the role of courts when Section 33 has been invoked. I guess one other thing I want to mention that we haven't really talked about yet is just, we have these 3 different bills in Alberta. They're now laws. But the connection between them, I think, is really important. And it really shows how much further Alberta has gone than the other provinces. So the bills, Bill 27, which prevents the use of names and pronouns that are gender affirming without parental consent, prevents a trans or gender diverse youth from being able to socially transition through, using their preferred names and pronouns. But then on top of that, we have this law that also prevents medical transitioning through hormone therapy. And then on top of that, we have limited access to education about all of these things. And we can probably assume that parents who don't support their trans and gender diverse kids are not going to be opting in to allowing them to have access to educational materials in these areas. So the cumulative impact of these different laws working together, I think, is really concerning. And so far in Alberta, we only have a challenge to Bill 26, which is probably the most potentially harmful bill. And so, we have public interest organizations that have limited resources. They're targeting those resources where they think they matter most. But even if that litigation is successful, we still have the name and pronoun policy that we have to deal with, as well as these changes to education and the access of youth to education. And so I'm hoping that we see further legal challenges to those other aspects of the Alberta laws as well. And I guess the last thing I'll say is just how important I think it is that we all continue to use our voices to make these issues heard. It can feel pretty hopeless sometimes, I think, when the government does something like use the notwithstanding clause to override the rights of a vulnerable minority. But I'm thinking about a protest just yesterday at the University of Alberta Law School where Premier Smith was speaking and some students sat in the front row with signs calling her and her government out on the anti-trans laws that she and her government passed. And in this photograph, which has been circulating widely on social media, she was looking very uncomfortable. And it may be that type of protest doesn't result in immediate changes to the law, but certainly I think it's very important for us to continue to mobilize our voices to speak out when we see these sorts of injustices happening.
I know, and I feel like in that specific regard, it was nice as well because to see that sort of our lawyers up and coming as well are prepared to sort of stand up and say something. So that's always a reassuring sign.
Yes, absolutely.
But yeah, no, it's an interesting, from a completely outside standpoint, it's an interesting sort of legal minefield, for lack of a better word, that we seem to be in now. But it'll be definitely over the next few, hopefully months, it all can resolve, but probably a few years to see how it all plays out.
Yes. I think this is going to be an ongoing issue, and it will require continued litigation, particularly in provinces where governments are kind of susceptible to getting on this bandwagon. So the role of lawyers is important, but also just the role of the general public in ensuring that their voices are heard on these issues.
Mm-hmm. Yeah, no, like I said, it'll definitely be an interesting next little bit. And to circle back to the blog, for those who are listening, correct me if I'm wrong, but it's ablawg.ca.
Yes.
A-blog.
A-blog.
Yeah. And there's a ton of really great blogs about a variety of topics, but your most recent one on this topic was also a really good. If anyone who's listening wants to kind of hear more or read more about it, really goes into the different aspects and a lot more on what we've kind of briefly covered here today. But I really appreciate you coming in and going through that. That was a very impressive distilling of a lot of very complex and moving pieces into a, I think, relatively digestible sort of 30-ish minute episode. So I really appreciate your time.
Thank you very much for inviting me, Madeline. It was good to talk to you.
And I'm sure we'll have you back again because it's now your second year in a row. So our regular friend of the podcast.
Happy to be here. Thank you.